Welcome, everyone. I'm Ann Petrick, Senior Director of Research at Vistage Worldwide, and I'm happy to host the latest webinar in our Peak Performers webinar series. This series is designed to support your leadership climb by bringing the most trusted experts to the Vistage community. Experts who provide exceptional insight and best practices, helping you navigate new challenges and possibilities. Speaking of challenges, in anticipation of drastic changes to the tax policy based on the Biden administration's proposal, reassessing your assets from both asset protection and estate planning perspectives may save you and your beneficiaries from extreme tax burdens. Joining us today is Hillel Presser, who is the founder and managing partner of the Presser Law Firm and is also a Vistage member and speaker. He represents individuals and businesses in connection with the establishment of comprehensive asset protection plans that incorporate both domestic and international components. He's been featured in media and press internationally, including Forbes, Sports Illustrated, The Raw Report, along with various network television stations. Hillel has represented some of today's most well-known business owners, doctors, celebrities, and professional athletes, and is also available to come to Vistage groups. Hillel, welcome, and let's turn it over to you.
Perfect. Thank you so much for the kind introduction. I'm just going to go ahead and dive in because we have a ton to cover today. And what we're going to do is, before we get into essentially the potential minimization of taxes, we're going to talk about asset protection and estate planning for a while first, because it's really important that we understand how to implement these entities. That way we can use the entities for potential tax savings. So without further ado, let's get started. We're going to have a lot of fun today, as much fun as we can possibly have talking tax and law. So here we go. Probably the first question I ever get asked is why I became an asset protection attorney. And as far back as I can remember, if you would have asked me what I was going to be when I was 10 or 15 years old, I would have told you hands down I was going to be a lawyer. And it probably had something to do with the fact that at that point, I was very close with my Uncle Jimmy. And Uncle Jimmy was one of the first personal injury attorneys to ever advertise on TV. Now, while I knew him as Uncle Jimmy, the rest of the world knew him as Jim the Hammer Shapiro. And he used to get on TV and scream at the top of his lungs, "I'm Jim the Hammer Shapiro. I'll wring out every penny, squeeze out every dime. You don't have to like me, just make sure you call me. I may be an SOB, but I'm your SOB." And I'm going to take 30 seconds just to show you one of Jim's many ads.
Hurt? I cannot rip out the hearts of those who hurt you. I cannot hand you their severed heads. But I can hunt them down and settle the score. I'll squeeze them for every dime I can. Every single dime. I'm Jim the Hammer Shapiro. But I cannot proceed until you call. 1-800-546-7777. You call, I hammer.
Now, because we're on a strict time limit, I won't show you my favorite ad where his face actually pops out of the zero of the 1-800 number, but you guys get the point. I don't show you these ads because I'm proud of Uncle Jimmy. I show you these ads because this was 30 to 40 years ago in upstate New York. Today, this is the norm. Every bus bench, every radio ad, every TV ad, who can I sue? How do I take the money out of the hardworking business owners like yourself and redistribute the wealth? So while there's thousands of personal injury attorneys and other types of attorneys in every city trying to find a way to take your money, I thought it'd be pretty neat to be one of only few asset protection attorneys in the country that actually teach you how to protect it. So I am the lawyer that hates lawyers, and I help you protect every personal asset and every business asset to make you uncollectible and judgment proof. So why do you even need asset protection? I have a cute little cartoon, and it's two lawyers talking. One says, "I say sue," the other one says, "anyone in particular." People smile when they see this, but this is the reality. I'm a Vistage member, just like you. I get together with my group once a month to learn from each other. The lawyers do this, but they get together to find out who's their next target. There's 100 million lawsuits every single year, and that number is only growing. Lawsuits have literally become the next biggest business. There's a 1 in 4 chance you'll be sued in the next 12 months, and the average person and business is sued about 5 times over their lifetime. Now, these are just nationwide stats. Maybe if you live in rural Kentucky, there's not as many lawsuits as South Florida. Maybe if you have 5 employees versus 200 employees, but these are the nationwide stats. There's a 50% chance of divorce. When I give the speech in Miami, I say there's a 90% or 99% chance of divorce. And a lawsuit can cost you tons of money, even if you win the case. So you could spend hundreds of thousands, if not millions, defending yourself. So if you win, you've already really lost. Therefore, the trick is not making money, it's keeping it. And the challenge I give to every one of my Vistage members, because I know what it's like, it's about growth, 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 is for every 60 minutes you spend making money, stop and spend 60 seconds thinking about how to protect it. So what will a well-structured asset protection plan do for you? Number one, discourage lawsuits. I can't tell you how many times someone will threaten to sue my client, will go to the back of the office, get their file, copy it, and FedEx it to the other lawyer, of course, with a copy of my book. We'll tell them everything my client has and where it is, just the fact that they can't touch it. Most of the times, the lawyers won't even want to sue my clients because they're uncollectible and judgment proof. The lawyers want the easy kill. They want to go after the low-hanging fruit. If a lawyer does sue you, you want to be able to negotiate an inexpensive settlement. We helped settle a $20 million lawsuit for $250,000. We helped settle a $5 million judgment for $500,000. You want to protect your assets from judgments, reduce insurance costs, keep your wealth safe from other financial threats, and most importantly, help achieve your other financial objectives. This is really important today when we start talking tax towards the end of the presentation. There's no point of having a good asset protection plan, protecting everything that you have while you're alive, if when you die, your assets don't go where you want them to go. There's no point of having a good estate plan and making sure your assets go where you want them to go if you lose half of your estate to the government in taxes. So you got to make sure your team is talking. You always need to be thinking asset protection, protect what you have while you're alive, estate planning, pass it on when you pass away, tax planning, pay the least amount of taxes that are legally and ethically possible. And of course, there's other things as well, like business succession planning, financial planning, accounting. So 8 keys to a good asset protection plan. Number one, protect every asset. First thing I make a client do when they come into my office is inventory their wealth. Everybody has more than they think they do. People think about the money, people think about the real estate, but what about shares in your corporation? If you get sued, you can lose your entire business. What about intellectual property, patents, trademarks, domains, phone numbers? What if somebody owes you money? What about inheritance? What about business assets? The first thing you need to do is inventory everything you have to make sure every single asset is protected. You, of course, always want to keep everything 100% legal and 100% ethical. And you always want to keep things as simple and cost-effective as possible. I can't tell you how many times someone will buy one of my books on Amazon, they call me and they want some very sophisticated, complex plan. No. Start off small. As your assets grow, your plan can grow. As your education grows, your plan can grow. You want to keep it simple and cost-effective. Of course, you want to make sure it fits your other financial goals. We talked about making sure that your team is talking. And most importantly, you want to make sure it allows you to retain control. The whole key with asset protection is own nothing, control everything. Own nothing, control everything. Laws change, so of course you want to keep your plan up to date, and you have to be comfortable with your plan. Your plan should allow you to sleep at night. So maybe you have a lot of liquid assets and you should have an international component, but if you don't feel comfortable with international asset protection planning, don't do it. And most importantly, you want to make sure that it's totally effective against any threat. It shouldn't matter if your neighbor's suing you or the most powerful attorney in New York City, your asset protection plan should stand the test of time. So 3 maxims to an asset protection plan. Number 1, protect yourself before you have a problem. You don't get the car insurance after the accident. You don't get the life insurance after the death. You don't get the health insurance, after you get sick. You have to be proactive. You also want to start with a basic plan and add firewalls as needed. And most importantly, don't look for one magic bullet. Asset protection is not cookie cutter. Asset protection should be individualized and customized and tailored. Everybody's personal and business assets are different, Everybody's potential threats and creditors and liabilities are different. So what may work for you might not work for someone else. Someone who may be protecting against a third marriage is different from someone who's protecting against a teenage driver or after selling their business. 5 biggest mistakes to avoid, and there's tons of them. Number 1, hiding your assets. Asset protection is not about hiding. It's not about secrecy. It's about protection. And with a good asset protection plan, you should be able to tell everyone what you have and where it is. They just shouldn't be able to get to it. You never want to go titling your assets to straws. I can't make these stories up. A guy came into my office and he said, "Oh, I'm being sued, but don't worry, Mr. Presser, I gave everything to my best friend." I looked at him and I said, "What actually makes you think that your best friend has less legal and financial trouble than you?" The best friend got a divorce, and the best friend's ex-wife took my client's assets. You don't want to go titling all your assets to your spouse. We see this a lot with doctor clients. "Oh, I put everything into my spouse's name." They're the less vulnerable spouse. Nobody's immune from a lawsuit. Nobody gets up in the morning and expects to be sued. The husband or wife can get in a car accident, taking the kids to soccer practice. If you go and shove everything in one spouse's name, there could be some estate tax issues. You, of course, never want to commit any fraudulent transfers. You want to make sure that you're proactive. Don't do things after the fact. And you never want to break any laws. Keep it legal, keep it ethical. Okay. Hopefully by now I laid a little bit of foundation about what asset protection is, taking your chips off the table, why asset protection is so important, et cetera, et cetera. And I breezed through it quickly only because we have a lot to cover, but I had to lay a foundation. Now that we've laid the foundation, now let's talk about specific asset protection strategies and techniques. And then lastly, we'll talk about how to use those asset protection strategies and techniques to minimize taxes. So this is the most important slide I'm going to show you in this next section, because in the middle we have exposed wealth. And exposed wealth is anything that's in your personal name. It could be liquid assets like checking, saving, stocks, bonds, CDs, money markets, brokerage accounts. It could be real estate like vacation homes or office properties. It could be boats, planes, golf carts. It's anything of value that's in your personal name. And the reason why it's exposed is because if you get sued, you can lose all those assets. So just take a minute right here and think about it. What do you have in your name or the name of your revocable living trust? And understand that if you get sued, you can lose those assets. So the key is when we're done today, you don't want to have any exposed wealth, because any asset at all, whether it's money, real estate, shares in a company, et cetera, if they're in your name or your revocable living trust, if you get sued, you can lose everything. So let's not talk problems, let's talk solutions. 3 easy ways to fix it. My favorite is transferring the asset to a protective entity. This deals with owning nothing but controlling everything. There's tons of different types of protective entities: trusts, corporations, LLCs, limited partnerships. And we're going to talk about them in detail after this slide. If you have $500,000 in your name or your revocable living trust, you can lose it. But if you put that $500,000 in your protective entity, for example, your limited partnership, nobody can touch that money. If you have 3 pieces of real estate in your name or your revocable living trust and you get sued, you can lose it. Instead, if you take those 3 pieces of property and put them in protective entities, maybe LLCs, if you get sued, nobody can touch them. So one strategy, and it's probably my favorite, is transfer your assets that are exposed in your name or the name of your revocable living trust into a protective entity. And we'll talk a lot about that next. Another strategy is to convert into exempt assets. Exempt assets just mean what assets are protected by your state. Florida protects different assets than Georgia. Georgia protects different assets than California. California protects different assets than New York. We'll talk in a little bit about what are some of those exempt assets that these various states do protect. And then lastly, protect with liens. And I make a joke here: poverty is power. What's a $100,000 Mercedes worth if you owe $95,000? What's $1 million house worth if you owe $950,000? there's ways to strip the equity from your assets to make them valueless and unattractive to a lawsuit. So let's dive into these three strategies. Number one are LLCs. LLCs are probably one of the most common used business entities for asset protection. I love to use LLCs all the time when I'm dealing with dangerous assets or business activity. I love to use LLCs for businesses. I love to use LLCs for real estate. I love to use LLCs for toys like golf carts and jet skis. Think about it. If you have a piece of real estate in your name and you get sued, you can lose the real estate. If you have a piece of real estate in the name of the LLC and you get sued, you can't lose the real estate because you don't own it, the LLC owns it. If you have a piece of real estate in your name or the name of your revocable living trust and somebody gets injured on the real estate, they sue you for everything you own. If instead you put the piece of real estate in an LLC and somebody gets injured on the property, they can only sue the LLC, they can't sue you. If you have a jet ski or a golf cart or a boat or a plane, if you have those toys in your name and you get sued, you can lose them. If you have them in the name of an LLC and you get sued, nobody can touch them. If you have a toy in your name and there's an accident, golf cart tips over, boat runs someone over, jet ski runs over a snorkeler, you can be sued if you own that toy. If it's in the LLC, as long as you're not the driver, only the LLC gets sued, not you. So I love using LLCs for dangerous business activities, real estate, toys, businesses, things of that nature. Probably one of the most used business entities for asset protection. Just keep in mind, LLCs have not been around too long, 30, 40 plus or minus years. So we're still learning. Every 2, 3, 4, 5 years, cases could come out that change LLC law forever. So they are a newer type of entity. Keep that in mind. Corporations, probably the worst type of entity to use. Anyone who has an SCorp or a CCorp, we need to fix that immediately. So think about it. If you own an SCorp or a CCorp, well, you own shares in the SCorp or the CCorp. And if you get sued for anything, a car accident, a divorce, a slip and fall, a breach of contract, just like if you had money or real estate or a toy in your name, if you have shares in a corporation, like an SCorp or a CCorp in your name, you can lose it. So if you have shares in an SCorp or a CCorp in your name, we need to figure out either A, how do we convert that SCorp or the CCorp to an LLC, which gives you better asset protection, or how do we get those shares of the SCorp or the CCorp out of your name where they're unprotected and into some type of entity where it is protected. Exemption laws. Exemption laws deal with assets that are protected by state law. And I'm going to go through Florida for you, but understand a lot of them are different. Homestead. In Florida, your primary home is protected. It doesn't matter if it's worth $200,000, $2 million, or $20 million. Your home is protected. In California, your home is only protected from about $75,000 to about $100,000 or $150,000. In New York, only from about $75,000 to $150,000. So it depends on the state. Retirement account, wages, annuities, life insurance, all protected in Florida. Contrast that with Georgia. Georgia only protects life insurance up to about $4,000. So again, every state is different. But what exemptions are there certain assets that may have protection simply by state law. And if you go to our website, it's www.assetprotectionattorneys.com. There's a button that says financial exemptions. And if you hit it, we list every single state. So rather than go through every state, feel free to go to the website and click on your state. Co-ownership, tenancy by entirety, really neat thing for those married. It exists in about 25 different states, and it's only for spouses, and it's only for living spouses. So you have to be married and you have to be living. If there's a divorce, you can't use it. If there's a death, you can't use it. But what tenancy by entirety is it's really, really neat because it doesn't cost you anything. It's just a form of titling. And what it essentially states is that the assets of both spouses are not subject to the creditors of one spouse. So I'll give you an example. Husband has $200,000 in his checking account. If he gets sued, he loses it. Wife has $200,000 in her checking account. If she gets sued, she loses it. If the husband and wife take the $200,000 each and transfer it into one account and they label it tenancy by entirety, again, doesn't cost them one penny. If the husband gets sued, they can't lose anything. If the wife gets sued, they can't lose anything. The only time they can lose the money is if both the husband and wife get sued at the same time, which normally doesn't happen. Normally, one might get sued in business, another for a car accident. So for those who are married, tenancy by entirety, really, really neat, doesn't cost you anything. My wife jokes and tells me I only married her to get this extra protection. And again, if you go to our website, it's www.assetprotectionattorneys.com. We have a tenancy by entirety button. You can click it, see if there's tenancy by entirety in your state, and then you can see in your state if it's only for real estate or if it's for other assets as well. Limited partnerships, really, really great entity. I use limited partnerships a lot as a holding company to either hold liquid assets or own interests in other entities. So let's say we have an LLC, the limited partnership might own the LLC. Let's say we have another limited partnership. The limited partnership might own the limited partnership. And the things I like about limited partnerships, and again, I use them for what I call safe assets, is they've been around forever. I think they've been around from memory, gosh, going back to like the early 1900s. So we really know what's going to happen with limited partnerships. The law is not really changing a lot like it is with LLCs. And again, we use the limited partnerships a lot to protect essentially liquid assets, and then to own other safe assets like shares in C corporations, membership interests in LLCs, other ownership interests in limited partnerships. And when we talk about the tax in the next section, I'm going to come back to the limited partnerships because it's really neat. You can use the limited partnerships to actually get a state tax discounts. So really, really important that we come back here. Okay. Like we talked about, limited partnerships we use for the safe assets and for potential estate tax discounts. And LLCs we use more for dangerous assets and business activities. And of course, we can combine them. Okay, I've completed section 2 of 3. We've talked about section 1, what asset protection is, why it's so important. We've laid the foundation. We've talked about section number 2, which is what are different types of asset protection techniques and strategies and entities that you can use to protect yourself. Now we're going to talk about the third and final section, and then we'll go into real lifetime Q&A. About how do we essentially use those asset protection techniques and strategies to hopefully save and minimize taxes. So let's talk now. First of all, there's different types of trusts. Lawyers will tell you there's dozens and hundreds of trusts. A lot of times it's because they have their own trusts with their own name, but most trusts come back to 2 types of trusts. One is a revocable trust or a revocable living trust. And another one is an irrevocable trust. Probably the biggest misconception I get every single day on a daily basis are revocable living trusts. People come into my office with a revocable living trust and they think they have asset protection. They think they have tax savings. They have neither. A revocable trust is just what it sounds like, a revocable trust. So if you put something in a revocable trust, any type of asset, you can take it out at any time. That means that if you get sued, a judge can order you to take it out. That means if you put something in there, it's not going to give you any tax benefit because it's not irrevocable. So biggest misconception I see on a daily basis is client walks in with a revocable living trust, thinks he has asset protection, thinks he has tax planning. He has 0 asset protection planning. He has 0 tax planning. That doesn't mean that these trusts are not good. I love these trusts from an estate planning point of view, not a tax planning and not an asset protection planning. They help you avoid probate. They limit legal fees when you pass away. They keep things private and anonymous. They get assets where you want them to go quicker. But again, no asset protection, no tax savings. The other type of trust is an irrevocable trust. And this is not as common because it's irrevocable. The way that an irrevocable trust works is once you put an asset in, you can never take it out. So a lot of people are hesitant to do this because it is irrevocable. With this being said, irrevocable trusts do give you asset protection, and irrevocable trusts do give you tax savings. So let's talk about this, and let's just talk about life insurance to start, because this is an easy way to save. Anybody who has a life insurance policy who owns it in their personal name, let's pretend you have a $5 million death benefit and you're going to leave it to the 2 kids. You can change the amount on the death benefit and you can change the beneficiaries. I'm just giving an example. Well, if you pass away, that $5 million that you think is going to the 2 kids is included in your taxable estate. That means, let's say there's no exemption when you die. Right now, there's an $11 million exemption, but it's going down. Let's say there's no exemption when you die and you have no other assets. That $5 million is included in your taxable estate, even though you didn't have it until you died. And from that $5 million, you're probably going to pay about 40 to 50% in estate taxes. So for easy number, the kids get $2.5 million and the government gets $2.5 million. Not the best scenario. With that being said, probably 8 or 9 out of 10 people who walk into my office with life insurance policies have the life insurance policy in their name. What can you do? You can set up a simple entity. It's a trust. It's called an ILIT. It stands for an irrevocable life insurance trust. And all you do is you put the life insurance policy into the ILIT. Now, when you pass away, there's no estate tax because you don't own the policy, the ILIT does. So take the same example, $5 million death benefit, 2 kids. Now, when you die, instead of the $5 million being included in your taxable estate and half going to the government and half going to the kids, now none of the $5 million is included in your taxable estate. The $5 million passes 100% estate tax free right onto your 2 kids, and you literally save $2.5 million. Now, why doesn't everyone do this? Number one is people don't know about it. So you might have a great agent selling you a life insurance policy, but they might not be a tax attorney. Number 2 reason is people think they don't need it. They say, wait a minute, the exemption today is $11 million. Well, I don't need it. I don't have $11 million. The problem is we don't know when you'll die. We don't know how much you'll have when you die, and we don't know what the exemption will be when you die. Right now, they're trying to get it down to 3, 4, 5 million. So again, if you think you don't need it because there's $11 million exemption, think again. I always say hope for the best, but prepare for the worst. And if you want to take an existing life insurance policy and put it into an ILIT, you can. It's a 3-step process. Number 1, have your attorney create an ILIT. Number 2, have your life insurance agent transfer the life insurance policy into the ILIT. And then number 3, stay alive for 3 years. There's a 3-year look back period. If you die 2 years later, you pay all the taxes. If you die 3.5 years later, you pay no taxes. And if you think about it, it makes sense. The IRS, the government, doesn't want you creating an ILIT and transferring your life insurance policy when you're age 98 on your deathbed. Another thing with the ILITs, as we talked about, is they're really good for asset protection, not just good for the people who set them up, but for the beneficiaries as well. And this allows you to literally pass wealth generation to generation without any taxes at all. Another really, really big strategy I want to talk about, 2 others I want to cover today. Number 1 is the annual gift exclusion. You are allowed to give away $15,000 a year per person to as many people as you want and not pay tax. That means if you're married, you can literally line up 1,000 people, and as long as they're different people, you can give all 1,000 people $15,000 each, and your husband or wife can do the same thing. So every person can give as many people as they want, up to $15,000 a year, every single year, no tax at all. Now, $15,000 may not seem like it's a lot of money, but when you take the $15,000 and you multiply it by 2, if you're married, it's $30,000. And then let's say you have 3 kids and you're doing it every year, that's $90,000 of assets that you're getting out of your taxable estate every single year. That's number one. Number two is you can use your lifetime exemption. Now, the lifetime exemption is currently 11, let's just call it 11 million for easy numbers, which means if you die with under $11 million, well, you don't have to pay tax. But if you die with $20 million, the first 11, you don't have to pay tax. And then 11 to 20, about half of that will go to the government in tax. Now, 11 sounds like a lot, and people say, I don't have 11 million in assets, and that's actually double 22 million if you're married, because it's 11 per person. But under the current administration, right now, they're trying to get that reduced to 3, 4, 5. And again, I think it'll go down, then I think it'll go up, then I think it'll go down. And it's kind of like, who gets caught holding the bag? Who are there enough chairs for you to sit in, when you're playing the game? So no one knows when they're going to pass. Nobody knows how much they'll be worth when they pass. Real estate could go up like it did now. It could go down like it did in 2008. And we don't know what the tax laws will be. So again, I would encourage you to hope for the best, but plan for the worst. So how do we use these exclusions? So we talked about the $15,000. That's really easy. You and or your spouse can give away $15,000 to as many people as you want every single year. No tax issues whatsoever. Helps you get money out of your taxable estate. That's pretty simple. Let's just spend the last amount of time on the other strategy, which is using your exemption. So let's kind of take everything we did today and talk about stuff that you can do. Let's say you have a brokerage account and it has $5 million, change the number to anything you want. And you have 5 properties that are worth $1 million each, change it to everything you want. And you have a business that's worth $2 million. So you have 12 million in assets, 5 million in cash, 5 million in real estate, 5 different properties, and 2 million in a business. And again, I'm just making this up as we go. And let's pretend that we've done some good asset protection planning. So the $5 million is in your limited partnership where it's safe. The 5 pieces of real estate worth $1 million each are in 5 different LLCs owned by the limited partnership. And then you have the business that's worth 2 million owned by the limited partnership. So you've put together a really nice asset protection strategy. Well, let me show you how you now can leverage that asset protection strategy to minimize your taxes. What you can do is you can gift the ownership in these assets, whether it's the real estate directly, the business directly, the money directly, whether it's the ownership in the LLC, whether it's the ownership in the limited partnership, you can gift them to irrevocable trusts. And if you gift them to an irrevocable trust, they now grow outside of your estate tax-free. Now, a lot of people are saying, but wait a minute, I don't want to give away my assets. I don't want to give them to my kids. I'm not ready to do that yet. I don't want to do this irrevocably. Well, what if you set up an irrevocable trust for your wife and you gifted half of the assets to the irrevocable trust for your wife? And then what if you set up a second irrevocable trust where your wife sets it up for you? Now, between you and your wife, you have the same, in our example, $12 million of assets, 5 million in cash, 5 million in real estate, and 2 million in business. The only difference is you have access to 6 of it. Your wife has access to 6 of it. So you still have access to the full 12, but now because they're in these irrevocable trusts, they're going to grow estate tax free. And when you pass away, if it's worth, the 12 is worth 20 or 30 or 40 million, there is no estate tax. So another really cool strategy is to gift the assets to irrevocable trusts. And again, if you're not ready to gift them irrevocably, maybe you do a gift for the spouse and vice versa, or things of that nature. Now, you could take this strategy and maximize it. There's what's called discounts for valuation. There's what's called discounts for lack of control, discounts for lack of marketability, et cetera, et cetera. So just because you have ownership interest in a limited partnership, you may not have control of the limited partnership. So while technically you may own X%, you may have no say. So the IRS allows for different discounts, and it could be anywhere 20, 30% plus or minus. So a strategy that you can do in that same example, we talked about an example where 5 million in liquid assets in the limited partnership, 5 million in real estate in the 5 LLCs, and 2 million in business. Well, that sounds like you're gifting $12 million. Well, what you can do is you can have all the real estate appraised. You can have all the LLCs appraised. You can have the limited partnership appraised. And let's say it comes back to the same number, 12 million bucks. Well, based on lack of marketability, based on lack of control and other things, you might be able to get a discounted valuation 20, 30%. And if you get a 20%, which is I think is on the low end, discounted valuation, now your assets are not looked at as being worth 12 million, but 20% of 12 million is 2.4, okay? Now they're only looked at being worth 9.6 million. So now when you make that gift, you're only gifting 9.6 million instead of the 12 million, which means in today's society, where you have an $11 million gift exemption, you'd still have roughly 2 million left to gift. So just to recap, and then we're going to go to Q&A. I wanted to save as much time as needed for Q&A, and I really, really encourage you to stick around for Q&A. I'm sure we're going to have some great questions. But just to recap, hopefully what we accomplished today, and I did in 30 to 40 minutes what we normally do in 3 to 4 to 5 hours, which is tough in itself. Hopefully you have a little background about what asset protection is and why it's so important. That's section 1. Hopefully section number 2, how do we implement an asset protection plan with techniques and strategies? And then number 3, how do we use those asset protection techniques and strategies to minimize taxes, estate taxes, gifting, tax planning, and things of that nature? What we're going to do is we're going to turn to questions in a minute. Before we turn to questions, I think Vistage just wants to do a quick poll, so I'm going to turn it over to them. If anybody likes what they heard today and they would like a complimentary preliminary consultation, please just check the box. I will speak to you personally. I deal with all Vistage members myself. If you'd like complimentary copies of our latest book, just check the box and we're happy to send them out. And like they stated at the beginning, I've been a Vistage member for a very long time. My firm has done probably over 500 Vistage speeches. So if you'd like us to come speak to your Vistage group, simply just reach out to us. And at this point, I'm going to turn it over to Vistage, and we're going to start the Q&A section in a moment.
Excellent. Well, I'll let the poll be open for just a few more seconds for people to select if they'd like to receive complimentary copies of the books or a consultation or both or all of the above. So thank you so much, Hillel, for sharing those strategies. I know we have a lot of questions around what do you anticipate the tax bill is, but first let's get to some questions that came in during this session. And first is, does the life insurance you referenced have to be paid from the ILIT?
So the short answer is yes, but you can put money in the ILIT. So instead of just literally writing a check, which is probably the simple and quick and easy way, the insurance premium each year, you do want to come from the ILIT. So depending on if the policy is on you or your wife or your kids, et cetera, the correct person would essentially write a check to the ILIT, and then the ILIT would write a check, to the insurance company. And I can't stress the importance here. I always tell my clients, honor thy structure. There's no point of doing any asset protection planning or estate planning or tax planning if you're not going to honor it. And the reason I say that is that if you don't honor it, you can't expect the courts and the judge to honor it. So short answer is yes, but always make sure you honor thy structure.
Okay, excellent. The next question we had is under the annual gift exclusion you talked about, you said that gifts not used or lost. Can you confirm and elaborate on that?
Absolutely. So when I say the gifts you don't use are lost, let me clarify. The $15,000 a year is lost. So if you haven't gifted any money for 10 years, you cannot go back and use those previous 10 years to gift $15,000 to as many people as you want. If you've just found out about this concept today,
Mhm.
then in 2021, you can gift $15,000 per person to as many people as you want. You cannot go back to 2020 or 2019, et cetera, et cetera. Now, with the overall exclusion, which today is 11.4, that doesn't matter if you gift it today or yesterday or last year or next year, as long as the exemption remains 11.4, you can gift it at any time. Now, more than likely, let's say it gets reduced next year, or let's just say it gets reduced to 5 million. Next year, you cannot gift the 11.4. You lost it. You should have done it this year. And next year, you can only gift the 5 million if that's the new law. We don't know what the new law will be.
Right. And I think that's a great point, because we don't know what is actually going to be part of that. Okay, a couple more questions coming in. So someone who belongs to a boat club but doesn't own the boat, how do they protect themselves, as you can't actually put that boat in an LLC?
So twofold. Number one, if it's an expensive boat club and you're worried about the membership, if it's $5,000 a year, we're not so worried. Maybe it's an exclusive membership that's $200,000 a year. You could actually put your membership in an entity like an LLC. And that way, if you get sued, nobody can take your boat membership, giving the creditor the right to use your boats, because the right to use boats in a boat club, that's an asset no different than money in the bank. Now, with that being said, if you're driving the boat, you can be sued. So there's always two people who can be sued. It's the owner and the driver. In this case, you're not worried about being the owner because you don't own the boat. It's owned by the boat club. However, if you're driving the boat, that's the other party who could be sued. So it's half a joke, but if you hire a captain for $100 that day, you're safe to go.
Excellent. Thank you. That was a great answer to that question. Okay, we have another question. Under current law, if real estate and other assets are owned by an LLC, is there a step up in basis upon the death of the LLC shareholder in a single member LLC or a husband and wife ownership of the LLC?
Yeah, so long story short, you get this. First of all, when it's a husband and wife, you don't need to worry about taxes. And I say that because a husband can pass as many assets as they want to a wife can pass as many assets as they want to a husband with no estate tax. So that $15,000 rule doesn't apply to husband and wife. That $11.4 million rule doesn't apply to husband and wife. Now, once the second spouse dies, it does apply once you pass it to the children. But a husband and wife can pass as many assets as they want back and forth. In regards to the step up in basis, you still, under today's law, and again, we don't know what's going to change. Everything is totally up in the air right now, but you still get the step up in basis, whether you have the LLCs or the limited partnerships, or whether it's owned husband and wife, as long as they don't get put in irrevocable trusts. So once you start taking the asset or the LLC or the limited partnership that owns the asset and putting it into a irrevocable trust, you then essentially have chosen to take no estate tax, but you're giving up the step up in basis. I always choose, I'd rather have no estate tax versus the step up in basis, but that's just my opinion. And again, we'll see how the laws play out.
Okay. Next question is, can you elaborate on limited partnerships protecting LLC structures? This member has a scenario with 5 owners comprised of LLCs that own an umbrella LLC. Should they consider a different structure to protect liquidity in the umbrella organization?
Yeah, so depending on where that umbrella LLC is set up, we need to see if there's something called charging order protection. And if there is charging order protection, we need to see, is it exclusive? If it is exclusive, we need to see if it applies to both single member and multi-member LLCs. So it's tough to answer that question without knowing all the facts. But I'd say there's a very good chance that the LLC holding company is not protected, which means if any of the owners of the LLC holding company get sued personally, they can lose their ownership interest in that LLC umbrella. which means they can then lose their interest in the other LLCs that the umbrella owns. So again, I don't want to be the doctor who prescribes all the medicine without knowing all the symptoms, but you may want to consider having a limited partnership own your 5 or 10 or 50%, whatever it may be, in that umbrella master LLC. And again, I would defer to seeing all the facts, but from the little I know.
Okay, sounds like a great opportunity for that consultation. All right, so some questions. I know we don't really know, but what are the biggest changes regarding the new tax bill and an asset protection structure? Is there anything that you have any sort of view into?
Sure. So look, first of all, I don't have any inside information. Anybody who tells you they know the answer is either lying or doesn't know what they are doing. What do I think? I think it's pretty clear the estate tax is going to go down. If it's 11.4 million now, whether it goes to 6 or 5 or 3, I think it's pretty clear it's going down. It's already set to automatically sunset to around 5 million plus or minus in a few years. So we know it's going down, but I do believe it's going to go down much quicker. There's a lot of other talks about, increasing cap gains. I think that'll happen. Again, no one knows for sure, but I do think that'll happen. And understand it's the yo-yo effect, right? Depending on what administration is there, it may go up, it may go down. And this is going to happen every 4 years. And it's just kind of like, when do you die? What are you worth? And what are the laws? And it's a crazy thing to say, but there was 1 year where there was no estate tax limit. And there was literally billionaires who were on ventilators for years, and people chose to pull the plug that year because there was no estate tax. And it sounds crazy, but that's how it gets.
Okay. Well, another question regarding the tax bill: how would a well-structured estate plan help someone in regards to what you might expect from what you just outlined?
So an estate plan, and I don't want to confuse it, an estate plan is great if you pass away. It tells where your assets go. It goes privately, it goes quick, it goes with less legal fees and taxes. That's fantastic, but that's an estate plan, so it will help you. It doesn't help you while you're alive. That's why you need an asset protection plan. It doesn't help you for taxes. That's why you need a tax plan. So when you say estate plan, I would just caution and make sure that we have what I'd rather call it an integrated plan.
Okay.
I want a client to be protected while they're alive, have their assets go where they want it to go when they pass, with the least amount of taxes and lawyer fees that are legally and ethically possible.
Okay, so really looking at those 3 things. Okay, what is the type of entity that might be most favored in the new tax implications?
It's really, unfortunately, it's just unknown. Again, I like limited partnerships because they've been around so long. They've been battle tested. They've been war tested. LLCs, it's easier for them to change the law. But to be honest, they do whatever they want to do. I mean, they're talking about changing the status of trust, which would, trusts have been around forever.
Yeah.
And that would just be a complete nightmare. So, they're trying to take 100 things, throw the darts against the wall, and they're just trying to have as many of those darts stick as possible. Now, whether 100 out of the 100 stick or 5 out of the 100 stick, hopefully there'll be some sort of compromise, and at least there's some give and take.
Yes, well, definitely, if and when that passes, we would love to invite you back to share some of the implications once we actually know what is in there. One more question. We were talking about trusts, and what is the cost benefit analysis of having an international trust?
Sure. So when you talk international, that's when planning gets expensive. It's expensive to set up international trust. It's expensive to maintain an international trust. So if someone has, $500,000, we're not talking international trust. If someone has, $3, $4, $5 million, we are talking international trusts. And international trusts are so protective because the trust is outside of the United States and the asset can be outside of the United States. So you've essentially removed yourself from the US legal judicial system, where the US courts and judges don't have jurisdiction over the trust and the asset. They work the best and help protect the best when it comes to liquid assets. So if you're talking to about a US business, it's not going to help you so much. If you're talking about like US real estate, it's not going to help you so much. But if you have liquid assets, that's where you'll really see the value of added protection through an international trust.
Okay, thank you. Okay, one last question before we wrap. If a C Corp stock is owned by a limited partnership, is corporate income tax paid at the C Corp level or the limited partnership level?
Sure, good question. It's not going to change. So when you have a C Corp, the C Corp pays taxes. And then once the money comes out of the C Corp, normally, let's say it flows to you, let's just call it to John Smith, then John Smith pays taxes. That's not going to change here. So let me explain. If you have a C Corp owned by a limited partnership, the C Corp will pay taxes. And then once money is distributed from the C Corp to the limited partnership, the money that goes to the limited partnership is normally just a pass-through entity.
Mm-hmm.
So the money that goes from the C Corp to the limited partnership will actually pass through to John Smith's individual tax return, where then John Smith will essentially pay taxes because John Smith will get a K1 from the limited partnership. So short and sweet, it's not going to change what's currently going on.
Okay, fantastic. Well, thank you so much for being with us today and sharing your insights, Hillel. And for our members, we'll be sending a link to today's recording and the slides within 24 hours from now. So I hope you can join us next month or later this month and next month for 2 more great webinars. On October 29th, Vistage speaker and president of Boost Profits, Casey Brown, joins us to share insights on developing a strong pricing strategy as part of the decision factors from our latest Vistage research report that was just released this week. And on November 5th, experts from UBS will guide us on how to look at environmental, social, and corporate governance, also known as ESG, positioning the impacts of company value, and how to share that story to employees, customers, potential investors, or acquirers. So you can register for these webinars at vistage.com/webinar. That's vistage.com/webinar. So thank you so much for your time today, for our presenter, for our attendees. Be safe and be well.